Hello, I'm DRoger, General Counsel for Las Vegas Police Protective Association. In this video, I'd like to talk to you about the Trespass statute, and specifically as it applies to motels or extended stay apartments. NRS 207.200 is our trespass statute, and there are a number of ways a person can be charged with trespass. If a person is on a person's property with the intent to, quote, vex or annoy the occupants, that is one basis for charging a person with trespass. If they are on the property with the intent to commit an unlawful act, that is another way. And then the next section that we are going to discuss is when a person remains on the property after being given a trespass notice. And so the statute, generally speaking, carves out an exception for a person who is a guest as opposed to a person who is a tenant. And generally speaking, if a person is a tenant, then the owner has to go through the eviction process and can't use you as a tool to get the person off the premises. And so if a person is a guest, and that's specific in the statute, and guest is defined as a person who is entertained or to which hospitality is extended, including but not limited to any person who stays overnight, that person is a guest. They don't have a vested right to be on the premises past the time that the person says get out. And under those circumstances, if the person is a guest, you may trespass them, or the owner may trespass them, and if the person refuses to leave, you may charge them with trespass. But the question becomes, when is a person no longer a guest, but instead a tenant under the statute, in which case you back out and you let the owner go to court to go through the eviction process. And so the statute refers us to the landlord-tenant statute, and when you piece all of these statutes together, a tenant is a person who is entitled under a rental agreement, whether oral or written, to occupy a dwelling unit on the premises. And so what is a dwelling unit? And that really is the key. A dwelling unit is defined as a designed or intended to occupy in a residence or sleeping place by one person who maintains a household, or by two or more persons who maintain a common household. And so what does that mean for you? And so, we have a lot of these motels. Well, these motels, if it's just one or two nights and they don't have a written agreement, then they are not tenants under the statute. However, some of the extended stay apartments or motels where people can stay 30 days or longer and they make that their household, under those circumstances, the manager or the owner of the apartment or motel complex has to go through the eviction process as opposed to just trespassing the individual. And so, to state it differently, if a person is just a guest and they're just at a place overnight or a very short period of time, and they don't have a written agreement or oral agreement to stay for an extended period of time, they may be trespassed. However, if a person has a oral or written agreement to occupy the residence and use it as a place of household, i.e. there's a stove, there's a kitchen, or all of the different things that you would consider to be a household, then you can tell the owner that they have to go through the eviction process. I know that may sound a little complicated, but if you have questions, always feel free to contact me, even if you're out in the field, or contact your sergeant and let the sergeant make the call. But I hope that this video has given you some guidelines in order to make your job a little bit easier. Thank you very much for your time. As always, contact me at DRoger@lvppa.com or subscribe to our YouTube channel. Thank you very much.